I'm Mary Stuart King, an associate at Nexen Pruitt working in employment and labor law. In my last video, I talked about reviewing physician employment agreements from the position of a physician who just completed residency or fellowship. Today, I want to outline key contract terms that any experienced physician should know as they approach a new employment agreement. First, determine whether your contract includes tail coverage. Tail coverage provides protection for medical malpractice claims that are reported after the provider's policy expired or was canceled. For example, if a physician leaves their position for a new job, they will be covered for a certain amount of time against claims reported after they have left their position. Next, a physician should be aware of the implications surrounding indemnification clauses. The contract might require that the physician indemnify, hold harmless, and defend the employer from any and all loss, damage, cost, and expense the employer may suffer that is in any way related to the physician's performance or failure to perform the services, responsibilities, and duties the physician has agreed to perform in the contract. It is important to understand when this clause applies to the physician, such as whether it is limited to instances in which the physician acts with willful malfeasance or acts in bad faith. You should also be aware that the clause can include reciprocal language, meaning that the employer would have to indemnify the physician for any of the employer's acts. The physician should also review any non-compete provisions in the contract. These typically prohibit the physician from working within a certain region for a certain time period if they are to leave their current employer. Forfeiture provisions, however, allow the departing physician to work for a competitor, but impose financial consequences for such decisions. Agreements may also have non-solicitation provisions, stating that physicians may not recruit patients or other employees to leave the employer with them. Physicians whose practice is hospital-based and thereby provides privileges should understand the differences between being an employee and a member of the medical staff with privileges. These relationships are separate, but in some cases can impact each other. For example, in practices such as radiology, anesthesiology, and pathology, you may automatically lose your privileges if you are terminated from the practice group. As experienced labor and employment attorneys, Nexen Pruitt is well positioned to assist physicians in evaluating their employment agreement to ensure a fair contract for all parties.